The legal system is designed to protect our rights as citizens. But what if a law is passed that does the opposite? The U.S. government has a solution for that: the Judicial Branch. When the framers created the Constitution in 1787, they recognized the need to establish a system for administering justice. Article 3 of the Constitution established the Supreme Court as the highest court in the land and defined the type of cases it could hear, such as cases involving the United States itself. It empowered Congress to create lower courts if needed, but the Constitution did not outline how the judicial branch would function. Congress passed the Judiciary Act of 1789, which was the first major step in shaping the federal judicial system. It set the number of Supreme Court justices and created the role of Chief Justice. It also set up the lower federal court system and divided the country into judicial districts. Now that Congress had decided how the court system should work in theory, it was over to the Supreme Court to decide how it should work in practice. In 1803, the Supreme Court itself set an important precedent in the case of Marbury versus Madison, when it ruled that the court had the power to strike down a law if it violated the Constitution. The Supreme Court used this process called judicial review, keeping the legislative and executive branches in check and protecting the rights and freedoms of U.S. citizens. The impact of the Supreme Court on the United States over time has been significant, but it derives its most important powers to interpret the Constitution and the constitutionality of laws in the United States from decisions made in the earliest years of the judicial branch's history.